March 6, 1857, history was made. Each of you tuning in should remember that this event happened in your lifetime. Welcome to the Silly Goober singular, not plural. Though the case had started in February of 1856, the actual conflict starts way back in the early 1800s. In an attempt to maintain the already strained balance between the two sides, Congress made the Missouri Compromise to decide which states are slave states and which will be free states. But don't be mistaken. This only caused the South wrinkles, worried that Congress might ban slavery altogether next. They were very wrong, considering the events that transpired this year. In comes Dred Scott, an enslaved person born on American soil. He was taken to Illinois and the Wisconsin Territory in 1834 by his owner, John Emerson. These two states would be important in the Dred Scott v. Sandford case. In 1840, he was taken back to Louisiana, a slave state. Just 3 years later, John Emerson passes away, leaving Dred Scott with his widowed wife. Thus began Scott's continuous fight for freedom. Even after losing multiple suits, even after being passed on to John Sandford, Mrs. Emerson's brother, Dred Scott never gave up on his freedom. Eventually, his freedom suit reached the Supreme Court. As a person invested in this, I did my best to try and get intel about the case. Alas, not every detail could be explained with my investigation alone. That is why I have brought very special guests for today's special broadcast. Please welcome Dred Scott, former Justice Curtis, and Justice Taney onto Silly Goobers, now plural.
It is a pleasure to be invited to this podcast.
Agreed. We look forward to working with you.
Now, a disclaimer before we dive into this case. This is a very fact-based broadcast. I understand that you three all have strong opinions on this, considering your involvement in the verdict. However, if you want to get emotional and biased, please record with another podcast studio.
Understood. We will not be bringing personal matters here.
However, there will be a segment where you are allowed to be more personal, so save it for that. Back to where we were. It was February 1856. Mr. Scott, are there any events regarding the beginning of the trial that you would like to mention?
Yes, I would like to bring up something that I found peculiar. In all years before I filed a freedom suit, the people who used the same argument as I have been allowed freedom. Yet none of the courts I appealed to, except for the circuit court, allowed me the same verdict. Something must have happened between when Winnie v. Whitesides took place in 1824 to 1840 when I first began my fight for freedom. I hope you don't take that as being biased. I am but offering insight on the situation.
No, you are fine. It is interesting that you brought it up. Chief Justice Taney and Justice Curtis, would you like to comment on this?
I cannot comment on the issue, as being a Supreme Court justice. Forgive me, I resigned not long before due to internal conflicts. So I need to adjust to no longer being a justice. Anyhow, the experience of being a justice has not aided me on information regarding the lower federal court.
What a nice show you have put on, former Justice Curtis. Though I too have no factual statements on why Winnie v. Whitesides was not utilized, I believe it was because there was not enough sufficient evidence that Mr. Scott and his family were under the ownership of Mrs. Emerson.
It's almost comical that they would say that whilst referring to my family and I as property.
I believe that you are all in need of a breather, so I will be taking over the narration. Dear listeners, here is where the case begins. We first have the petitioner's arguments. Firstly, it states that the land where John Emerson took Mr. Scott was free as a result of the Missouri Compromise. Secondly, due to the Winnie v. Whitesides Missouri Supreme Court ruling in 1824, Mr. Scott is now a free man because an enslaved person who was taken to a free state could not be re-enslaved, even when taken back to a slave state. Lastly, Mr. Scott was a citizen of the United States due to nothing in the Constitution saying black people, enslaved or not, could not be citizens. Because he was born on American soil, Mr. Scott was a citizen and could thus use the rights mentioned. Did I miss anything, Mr. Scott?
I believe you covered all the main points.
That's good. On to the respondents' arguments. Firstly, it states that the Missouri Compromise was unconstitutional because it took away the property rights of slave owners. By property, I meant the people that they enslaved. This violated the Fifth Amendment. Secondly, our framers never meant for enslaved persons to be citizens, as seen in the distinction between free and enslaved people in the Three-Fifths Compromise. For those of you unaware, the Three-Fifths Compromise states that the number of representatives each state gets will be calculated by adding the number of the population that is free to 3/5 of the population of enslaved people in the state boundaries. Lastly, the respondent states that one of the rights granted by the Constitution is the right to move freely in the United States. Since those who are enslaved cannot move freely, they cannot be classified as citizens. Did I miss anything?
No, those were the main points for Mr. Sandford.
Good to hear. Dear listeners, before we get opinionated, I hope you have already formed your views on the case. Whether you have based it on morality or technicality, every stance is welcome, so please leave feedback on today's broadcast to boost our engagement. Anyhow, Chief Justice Taney, how exactly did you come up with the majority opinion? If you cannot divulge, please still share what you can.
While I cannot recount everything word for word, I can share most of the details. The court began deciphering the Constitution, as well as the language of our framers. Especially in the Three-Fifths Compromise, we found lines that separated free citizens from slaves. Using this, we could conclude that the definition of citizens did not include slaves and their descendants, or more specifically those who were not white, and thus Mr. Scott could not have claimed his citizenship.
Although that may be true, I would like to ask some questions. Why exactly have you concluded that the distinction between the two warranted a different definition?
Perhaps if the article only differentiated free and enslaved people, that argument could be made. However, it essentially states that enslaved people are only worth 3/5 of an average free citizen. If their worth was not the same, how could they be the same?
Oh, I see. That does make more sense now.
In addition to Mr. Scott's specific case, the court found the Missouri Compromise unconstitutional due to it violating the Fifth Amendment, which guarantees all citizens of the United States life, liberty, and property rights. Justice McLean and former Justice Curtis both dissented, but the majority of the court agreed that the Supreme Court had jurisdiction to decide on the matter.
And how did you all come to that conclusion? Was there a specific amendment that justified this?
No. But as you may know, part of the Supreme Court's duty is interpreting the Constitution. If we have found a law unconstitutional, we may as well rule it that for ease in the future.
All right. Now, Mr. Curtis, would you please divulge your dissenting opinion?
Would you like the whole 67 pages of it or just a summary?
Although I am curious, please summarize it for the listeners before they fall asleep.
First and foremost, I heavily disagree with the fact that Mr. Scott, nor other enslaved people couldn't be considered citizens. It is a known fact, or so I thought, that black citizens were present in the United States when the framers wrote the Constitution. Therefore, black people were in the mind of the framers whilst writing the document. Had they not been, wouldn't there have been a clause or article in the Constitution that revokes all citizenship from black people? Secondly, I disagree with any further judgments made after the court ruled Mr. Scott was not a citizen. Both McLean and I are of the opinion that when the court found evidence of it not having jurisdiction, it should have ended matters there. The ruling on the Missouri Compromise was incredibly unneeded, and I'm glad at least one other person in this court could agree.
Your reasoning sounds very convincing, but could I ask something?
Please ask for clarification on any confusing parts, for you and the listeners.
If you proved that black people could be citizens of the United States, how would that relate to the majority's opinion? I mean, they clarified that enslaved people could not obtain citizenship, but they didn't say all black people, right? And Mr. Scott was enslaved by John Emerson, so how would he be proven a citizen? Do forgive me, I am not trying to sound ignorant here.
I can answer this. The court did specify that black people, slaves or not, did not have the right to sue in a federal court.
Oh, that's interesting.
Yes, although I could not specifically prove Mr. Scott to be a citizen, I still dissented against the ruling that dictated black people unable to be citizens of the United States. Though, in my dissent I did also add that the framers never stated owning enslaved people was a right, and there was also no article stating that it was the people's right to own them.
Yes, but stating that as a ruling would cause the South to be unequivocally enraged.
Thank you for clarifying. I'm sure many listeners had the same confusion as me. It is interesting to see how you should balance the Constitution and the current citizens.
Had only the issue of morality been present, meaning all political and constitutional influence gone.
I see. Let's get rid of the facts for a second. What were your opinions of the others' arguments, Justice Taney and Mr. Curtis? Mr. Scott, which one do you agree with more?
I find myself unable to agree with either argument fully, but I would rather pick Mr. Curtis' opinion over Justice Taney's. Even if I was not proven free, Mr. Curtis' ruling could have given more leeway for other enslaved persons to free themselves in court.
My opinion on Justice Taney's opinion, well, considering I wrote 67 pages, I hope the listeners can tell my attitude toward the conclusion. However, if I had known that what I said and wrote would be taken as an insult, I would have never written it.
Mr. Curtis, now you are putting words in my mouth. No one forced you to resign. You yourself said that your pay was better before you were in the Supreme Court. As for my thoughts on your dissenting opinion, it was incredibly persuasive. So much so that I had to write 18 pages back to refute your points.
I did attempt at trying to read the 67 pages, but I could not do it. Not even for you listeners. It was simply too dense of information.
I shall take that as a compliment.
It certainly is quite a feat, now that we have dived into the Dred Scott v. Sandford case. What's next? What was next for our country, and how did the people take it? Just 6 months ago in March of 1857, this case received its verdict. We are now in September of 1857, and let's go through the impact of this historic case.
I can go first. The impact was devastating for me and other justices.
I wonder why.
I had hoped that my rulings would quell the unrest between the North and the South, but the opposite seemed to have occurred.
That is correct. From what I could gather in the newspapers, the North is even more angered. It made them more opposed to slavery, and they felt that the South was being favored.
I suppose all we can do now is try to subdue public
The
chaos.
South, on the other hand, is growing bolder and bolder with their demands. They felt like they were backed up by the government and thus continued to make unreasonable requests. Overall, it is a political nightmare.
I sure hope that war doesn't happen.
You are spoiling the plot for humanity. Wait another 4 years before you speak. Anyhow, would you like to share your personal impact from the case with the viewers, Mr. Scott?
Delightfully so. I was blessed to have been supported by the public for the most part. Had that not been the case, my manumission would have been but a daydream. Now that my family and I are free, I have been working as a porter to support ourselves. It's especially nice thanks to the kind people who helped me after the case.
I'm happy to hear that you achieved freedom after so many years of fighting for it. After all, you wouldn't have been able to be here on this podcast otherwise. What about you, Mr. Curtis, and Justice Taney?
I resigned from the Supreme Court after the Dred Scott v. Sandford case.
Ahem.
Actually, I had been considering doing so for a while now. I was never a team player, at least not in the working environment I was placed in. I also earned more as the owner of a private practice, which is why it was ultimately more beneficial for me to resign. The internal conflicts that alienated me from the rest of the court were merely the final straw.
There is not much I can add to Mr. Curtis' statement. Again, there was a large amount of backlash for both me and the rest of the court.
I hope you and your colleagues are working through this. Anyhow, you all have graced the listeners today. Would you like to leave? I'll be sending in the rest of the payment by tomorrow.
Yes, I do require a much-needed rest after so much talking. I still have work tomorrow, after all.
Here as well. I still need to manage my practice tomorrow, so I'll be excusing myself.
The Supreme Court will be awaiting me tomorrow, so I'll take my leave.
Thank you all so much for coming here. I hope that this podcast was an enjoyable way to recount your experiences.
It was an honor to be invited today.
Now that our guests have left, let's talk as the silly grouper singular, not plural. I realize that some of you may be confused about the mentioned laws and amendments, so I will be explaining them here. The Winnie v. Whitesides and the Fifth Amendment were both important in the case due to them being the pivotal arguments of both sides. In 1824, the first freedom suit was filed in the Missouri Supreme Court. The case's rulings would be used many times in the future to free enslaved people by using the fact that they were brought to a free state. The Fifth Amendment that the respondent's side based their arguments on dictates that life, liberty, and property could not be taken away without a fair court hearing. Since enslaved people are regarded as property, John Sandford's property rights were being violated because Mr. Scott can't be freed without a fair court hearing. I do hope that you all leave a comment on what you would have ruled if you were a justice. And if you have any questions, please include them. Here is one fun fact about the case, as customary for every topic we cover on the Silly Cooper singular, not plural. Did you know that John Sandford's last name was always Sandford? Due to a clerical error, his name was spelled Sandford, which has remained the name for the case until now, and likely forever. That is all. If you enjoyed today's special broadcast, please leave 5 stars. If I get a 4+ star rating, I may do another special episode. Thank you all for tuning in. Remember to stay silly and don't be plural. Cooper out.